Good morning. My name is Patricia STROWBRIDGE, and I am the appellant in this matter. I am an adoption attorney who, under Florida law, is in possession of a validly executed consent for adoption from the legal father of KAG, the child who is at issue in this case, in favor of the paternal grandmother. Pursuant to Florida Statute Chapter 63.082, paren 6, I followed the procedures of that statute in filing a motion to intervene before the dependency court because KAG had been sheltered in August of 2012 because his mother was found murdered and his father had been arrested and charged with that murder. At the time that he was sheltered, he was placed by the dependency court in the temporary custody of the maternal aunt at the request of the Department of Children and Families. About less than 90 days after that, or approximately 90 days after that, on behalf of the paternal grandmother, I filed all of the pleadings requesting that I be permitted as the adoption entity to intervene in that dependency case pursuant to the statute and to change the placement from the maternal aunt to the paternal grandmother. That case had several hearings, and there was a change of judge, and ultimately there was a disqualification judge. It took several months, but eventually a hearing was held on the change of placement.
That sort of plays into your issue 3, and I had a hard time understanding what particular error you were alleging or trying to argue in issue 3 and what relief you thought you would be entitled to based on the delay that you said improperly occurred.
In issue 3, I have argued that the requirement of the legislature that a hearing be promptly granted and that there be an immediate transfer of custody if the criteria of the statute is met cannot be complied with if we are now over a year after the child was sheltered and almost a year after the documents were filed. But the relief that I would request is that...
You point out that you think that the filing of a motion to disqualify bumped the hearing till later and caused some if we found that was an error, what are we supposed to do about that if everything else?
Just direct that there be an immediate hearing set, a prompt hearing set.
You did have a hearing.
It was 2 months later.
Okay, but since you've already had a hearing with respect to that issue, is there any relief you're actually requesting?
We've not actually had the hearing yet. The court declined to proceed on the motion for change of placement because the court found the child was not in the custody of the department, and that's actually the first issue, and that's not a requirement on the motion to intervene. If you look at 63.082, the requirement that the language about in the custody of the department is actually in 63.082(6)A, which is simply a statement that says that those consents would be valid, binding, and enforceable by the court. The provision of the statute which talks about the intervention itself is actually found in another section of 63.082.
Addressing this with the trial judge, when you had the hearing, you agreed that if the trial judge found that the child was not in the custody of the department but was in the custody of the aunt, that this provision would not apply, correct?
I did not agree with the court on that. I did not agree to that.
I'm fine if you go ahead and rule that way because I'll just go to family court and deal with this, correct?
The point was an argument. The argument to the court was if you make this ruling that this only applies when a child is in foster care, then what you're essentially saying is that I do not need to follow the requirements of 63.082 paren 6, that I can simply go to the family court, file a relative adoption, complete that adoption, and file a habeas petition for the child to be delivered to my client, similar to what they did in the Baby Veronica case from the U.S. Supreme Court this summer, and that's not in the best interest of the child, and that's not the procedure that should be followed when a child is alleged to have been abused, abandoned, or neglected. So it was an argument. I wasn't saying to the court that you should do this, but basically that this is the effect if you do this, that this doesn't make sense to do this and remove these protections that are included in 63.082(6). Now, 63.082(6) doesn't create additional rights. What it does is it creates procedure to define constitutional rights that have existed since 1923 when the U.S. Supreme Court found that parents have a fundamental liberty interest, fundamental due process right to the care, custody, and management of their child.
As I understand the statute, it allows under certain circumstances, and that being when the child is in the custody of the department for the parent to go in and get an immediate change of custody, and that's what you were trying to do?
No, they can get an immediate change of custody if the criteria of the statute has been met, which does include a best interest hearing. That would not happen if I went to the family court. I could go to the family court, and on the authority of In re Holland, which was a decision from this court, I would be able to go into the family court in the same circuit, request the finalization of the relative adoption, which doesn't require that the client have custody of the child. That adoption would have to be finalized if proper consents had been filed and the statute had been followed. At that point, my client, the paternal grandmother, would then be the parent under the statute, and the department's ability to maintain, or the juvenile dependency court's ability to maintain a temporary custody order in favor of the aunt would only be appropriate if there were some allegations of abuse, abandonment, or neglect against my client, which there wouldn't be.
Doesn't make sense that you could ignore the lawful custody order that's in place and go to a different court and get a competing order without...
It's the same court. As long as they stay within the circuit, the jurisdictions would be within the Ninth Circuit, not
A different judge,
within the
different division, different...
Yes, you would, but in the In re SNW, the court specifically said that there's no problem with going to a different division of the same circuit court. The jurisdiction's in the circuit court, not the division of the circuit court.
We're almost at
as long as
7
it's
minutes
disclosed.
if you want to...
Yes, and I'd like to turn it over to the department because they obviously have a very significant interest in this case.
May it please the Court, I'm Rosemary Farrell for the Department of Children and Families on behalf of the state of Florida. The guardian ad litem in this case has challenged the standing of the department, the fitness of the parent whose consent is at issue in this case, and they have even taken exceptions in some of the areas that we clearly seem to be in agreement on. Our position, and I think it's important to...
All they argued was that you didn't preserve any issue for appeal below, so you really shouldn't be heard to make an argument here that you didn't make to the trial judge.
We did object below, and I think it's in my brief.
Yeah, I think that if you read the case law, saying we object doesn't really preserve much of anything in most circumstances. So to make the same argument that you're making.
Okay, I can file supplemental authority on that. Most of the case law about the standing of the department on issues that pertain to its duty under the law is from this DCA, as a matter of fact. But in any case, as an entity of the state, it is our responsibility to safeguard the due process rights of the citizens, the people of the state of Florida. We're a guarantor of due process, and the rules of professional conduct of the Florida Bar speak specifically about a prosecutor's duty as a minister of justice. The same is true of an attorney on behalf of the state of Florida whose responsibility it is to safeguard the best interests of the child and the rights of children and families. Our duties intersect the right of the individual. Where that goes awry, that's when the entity on behalf of the people of Florida becomes involved. In this case, the guardian ad litem has said that the father doesn't have rights either because they pronounced him unfit. Until and unless a court has taken away parental rights, a parent still has the right to control his child. And the law everywhere...
That's not true. I mean, the parent couldn't come in and after the child is sheltered, if the court orders custody in a person, the parent has no right to come in and say, no, you have to move the child here. I mean, that's just not true.
I filed, if we look further in the same subsection that we're actually addressing here, let's look at paragraph G, for example.
So you're saying that in all cases, you have to place, or the court has to place, a child who's been sheltered where the parent directs?
No, that isn't what I'm saying.
You said they had a constitutional
right to have a say in the control in what happens to their child, and that's provided.
They can be heard, correct?
I'm sorry?
They're a participant and can be heard in the proceeding, correct?
Yes, and they also are under this subsection, the court is directed that at such time as it's determined that reunification of a parent with a child is off the table, that the court shall advise the biological parent who is a party to the case of the right to participate in a private adoption plan. That's a right. It's stated as a right. It's framed as a right. We are not saying that the right to intervene, which is what this case is about, is equated or is equivalent to the right to immediately place a child. The statute addresses the best interest. There are two large areas of discretion for the court. One is to determine that a prospective placement, adoptive parent, is qualified, and second, to look at the best interests of the child, and it sets out what those best interests entail. First listed among them is the right of the parent to have a voice in that.
Well, the bottom line is this is a statutory construction question. The right to intervene is determined based on 630826. I mean, both parties agree.
In its entirety.
Yeah, if the adoption agency comes in and the child is in the custody of the department, there's a right to intervene. If the child is not in the custody of the department, there's no right. I mean, everybody seems to agree on that. Then the question is, what does custody mean, correct?
Which isn't defined in Chapter 39, interestingly. Legal custody is defined.
Right.
Temporary legal custody is defined.
The definition of legal custody apply?
Well, it's defined that it is, what it really has to do with, and it's addressed also under protective supervision, it is the status of a child in the care of an agency or individual. And children remain in the care of the department, whether they're placed with a licensed foster care entity or a relative caregiver or a non-relative caregiver.
They're under the supervision, but they're not in the custody of the department, correct?
Under 63022 subdivision 5, the legislative intent is stated that the department is supposed to cooperate to the utmost with adoption entities regarding any child which is in the care of the department. Our interpretation of custody is not that it is an attempt to define the specific locus of the placement of the child, nor that that should drive a decision to allow someone to come before the court and offer permanency for a child.
I mean, the statute says that legal custody for purposes of Chapter 63 is a legal status created by a court which vests in a custodian the right to have physical custody of the child and the right and duty to protect the child and to provide for him or her with food, shelter, etc. I mean, that's the statutory definition, right?
Right, and it also...
And that would be the aunt in this case. I mean, it would. The court said, I'm giving custody to the aunt. That's what the order said.
It is temporary custody. This is a child who is in the dependency court system and has no permanency. There's no permanent status. That is a relative caregiver under the law, which is still under the protective supervision under paragraph 63 of the same definitions that you're reading from, Your Honor. It means a legal status in dependency cases which permits the child to remain safely in his or her home or other non-licensed placement under the supervision of an agent of the department, and which must be reviewed by the court during the period of supervision. That is in the care of the department.
The statute also says that if the child is placed in the custody of the agency, that the agency decides who the caregiver is, correct?
That's correct.
Okay.
So
the statute makes a distinction between a child in the custody of the department and a child who the court puts in someone else's custody, and I just don't see just the plain language of the statute when you say in the custody of the department in the section that we're talking about. That it seems like, I mean, you have an argument that it shouldn't be construed according to its plain language, but I do not understand the argument that this child was in the department's custody given the plain language of the statute. That just doesn't...
Well, it's actually paragraph B that drives the right to intervene by the adoption entity, and that does not refer back to, I mean, if we're going to be looking carefully at this. It's not referring back to custody or the locus of placement. It says, upon execution of the consent of the parent, the adoption entity shall be permitted to intervene in the dependency case as a party. This entire section of the law deals with
And
consent.
I think that's what they were talking about, not your lack of standing, but the fact that on appeal, you're not supposed to make arguments to the appellate court for the first time that you didn't present to the trial judge, and you didn't present this argument. The only argument that was made to the trial judge was this hinges on the definition in that section of custody, and if custody means supervision, then intervention is appropriate. If custody means custody, then it's not. I mean, that's the way it was argued below, correct? It's the only argument that was presented.
Well, the only argument, I mean, the argument
It
is...
wasn't by you, it was by Ms. Strowbridge.
The argument is that intervention contemplates cases in the dependency court system where a child has not reached permanency, and the parent still has intact parental rights. That's embodied in all of the jurisprudence on adoption and dependency. The parent still has a voice. It's embodied in this subsection at paragraphs E, D, and D. The court still, after the intervention, we are not saying that intervention means immediate placement. Upon a determination that the parents are qualified and it's in the best interest of the child, it is a best interest-driven determination, but it would be unseemly for the department to attempt to elbow people away from the table who are posing a possibility of permanency for a child who hasn't achieved that as yet. So we would encourage the court to look broadly at the context for the paragraph that we're arguing about today.
Okay,
thank you.
Good morning. May it please the court, my name is Chris Carlisle. I'm here on behalf of the guardian ad litem. Also, Kate York from the guardian ad litem program is here. I think the best way to approach this argument is to start with the obvious and the simple, and then maybe get into the more esoteric issues, and we can talk about whether or not they were in fact preserved. But I think Judge Lawson boils this case down to the core, which is a statutory interpretation case. And these constitutional issues, whether or not they were preserved, I'll deal with them, but at its heart, the starting point has to be, what does the statute say? Legislative intent is determined by the clear wording of the statute, and only if the statute is not clear do we get into any intent beyond that. And in this case, the statute is clear. We have a definition or a phrase in there about the minor child being in the custody of the department. 6308-211 references 390135, which goes to the legal custody definition that was discussed earlier. By any definition, and by the definitions used in the statute, legal custody was in the hands of the maternal aunt and her partner at that time. That's what the statute says. That should end the inquiry. That was the issue that was discussed below and was presented to the trial court, and the trial court came to the right decision. There's no argument that the argument is, again, kind of attenuated, that supervision equals custody. It clearly does not. The statutory language is clear, and that should end this. Beyond that, again, we can talk about the intent of the legislature in this, and again, as argued in the brief, there was obviously a legitimate argument and a legitimate distinction to be made between those in the care of the state in a foster home versus those who have been placed in custody. And the legislature certainly has the ability to put forth a statute that recognizes the distinction between those two statuses, and that's in fact exactly what happened here. Turning briefly to the constitutional issues, I think, again, Your Honor was correct. There is certainly an issue of preservation on behalf of both parties in this case, and the state in particular. The state did recognize and again, going back to the custody issue, page 29 of the transcript, the state attorney, or the attorney for the department, at the hearing says, talks about there has been an order entered. It lists the maternal aunt and Michael Abel, and it goes on to list them as custodians. The order in this case, the department is recognizes them as custodians, gives them an order that they shall not move the child out of state, quote, so the state has recognized them as the custodians of the child. This is what the department was saying to the trial court when the trial court ultimately made that decision. Now they come back and attempted to raise a constitutional argument that was never raised below and was in fact not even raised by Ms. Strowbridge. To the extent it was raised very briefly in the motion for rehearing, that motion was abandoned, as we pointed out repeatedly in the brief. One other thing I think I have to point out, the department argued a few moments ago that our position was the father doesn't have any rights either. It's not true. The entire point of this matter was that the father did have rights. And if you look at page 27 of the brief, the argument was that the father clearly had rights, and nothing prevented the father, a party to the proceeding below, from filing his own motions in the trial court or from prosecuting his own appeal of the order. The father clearly has rights. The entire question here is whether or not the adoption agency or Ms. Strowbridge has the ability to intervene under this statute. There is nothing to stop the maternal grandmother from exercising rights and positions, and she has in fact filed her own adoption proceeding. The entire question is, do they, in this case, are they allowed to intervene, and is the consent valid? And based on the clear language of the statute, it is not. This is not to suggest that a final determination has been made regarding where this child should be or who should be in the care of it. Those matters remain to be seen. The entire question is, what does the statute say, and did the consent that was filed in this case fall under the statute, which it clearly did not. Turning briefly to the constitutional issues, we see the argument, and there has been recognized, obviously.
Make sure I understand.
Yes, Your Honor.
What the difference is. So if there's a right to intervene in this proceeding,
yes.
If the adoption agency has a right to intervene, the practical difference is that then changes the trial judge's inquiry. It gives a preference to the parent's choice. And it isn't just a general best interest, let's look at all the alternatives and see what's in the child's best interest. But if there is no right to intervene in this proceeding, wherever the adoption is filed, it'll be a more general best interest determination. Is that practically the difference?
I think that's exactly correct. And I think that, yes. In other words, yes. And I think Judge Altenburn in the SNW case in footnote 4 talks about his interpretation of this. And essentially, if this process is followed, if you're allowed to intervene, if this consent is validly put before the court, it essentially gives, quote-unquote, a preference that would not normally be there. I think it's certainly worth pointing out that it could never have been intended by the legislature that a preference would be given in creating essentially a grace period where a person has been accused of killing another parent in this case, and essentially giving them a grace period to make a decision to intervene in this child's life before his rights are terminated. Obviously, that is not the case. But I think your reading of the statute is correct. It talks about the best interests in subsection C and says, number one, we're going to see if this process is followed, are these people appropriate and the best interest of the child. Then in D, it recognizes the quote-unquote rights of the parent who's making this thing, and Judge Altenburn says that that provision is a recognition by the legislature that there are some fundamental rights that attach. But I think, again, going to the constitutional issue, if I may turn to it, the argument seems to be now that this statute is unconstitutional, which again was never raised below. But in order for it to be unconstitutional, it has to violate a fundamental right. And the fundamental right they continue to talk about is the right to care, control, maintain, et cetera, your own child. That right has been recognized as not being absolute. No one would suggest in this case that this father, after being involved in a dependency proceeding, after being essentially giving up his rights, somehow has an absolute right to determine where this child goes. He doesn't. They cite a case from the Florida Supreme Court long ago recognizing this, but we have cited at page 47 of the answer brief the Padgett versus Health and Rehabilitative Services from the Supreme Court in 1991, where they note that there's a limitation on this right. And and the ultimate welfare of the child must be controlling when we're talking about a dependency proceeding. This is not an average case where a fit parent is exercising the right to control the child. This is a case where the state has been forced to step in, take this child, and has been forced by the circumstance to do that. This right is not absolute. The case goes on to say the overriding principle that the ultimate welfare or the best interests of the child prevail over this fundamental right, if you want to call it that, but it's not fundamental in the sense that it's not absolute. So to suggest that somehow that this statute is unconstitutional because it's removing the ability of a parent to make the ultimate decision, the statute doesn't give the parent the ultimate decision. As you mentioned, I think at best it gives, quote, a preference, if in fact it is followed properly, to the decision of the parent. But again, under the unique facts of this case, I think that the statute should not apply. It was clearly never intended to apply in this circumstance. Beyond that, again, so I think, what does the statute say? It says what it says. The only way the statute can be undone and not do what it says is if in fact it was unconstitutional. That argument was never raised for a variety of reasons, and it clearly wasn't.
Why does it make any logical difference whether the child is in the custody of the department or in the custody of someone else for purposes of this entire procedure?
Well, Your Honor, again, the intent, we don't need to get to that with the plain language of the statute, but the argument is, and it was set forth in the brief, that there was an interest on behalf of the state to get children quickly into stable and appropriate settings and get them out of the care of the state, get them out of foster care in doing that. And once the court has intervened and has placed these children there, does it make sense to give a parent a preference to come back later on and say, or give them the ability to say, you know what, let's take them out of this appropriate setting that we placed them in and they've spent some time in, and let's reevaluate this. If they're just in foster care, which is not the ideal situation, which is not with a relative, as in this case, then the state is saying, in that circumstance, we're going to give you a little more leeway or a little more preference as to what you want to do. Now, can some disagree with that? Perhaps, but it is entirely inappropriate or entirely unreasonable for the state to have made that distinction. That's what the legislature apparently did here. And again, before we even get to the question of why they did it, we have to look at what the statute says, and the statute says in the custody of the department, which was, again, not present in this case. Other arguments, Your Honor, I think as you identified, I was somewhat baffled also by the question about the procedural history of this case and what the remedy in fact would be. If they prevail, then I'm assuming they'll have that hearing as quickly as possible before it. There were situations that occurred in this case that again, has happened in many, if not most cases, that delayed the proceedings for a period of time, but what is the effect of that? Again, I don't know what the remedy or the legal remedy was actually asked for there. Beyond that, Your Honor, I think, again, this is an interesting and horrible case in some ways that has many twists and turns, but at its core, it comes down to what does the statute say? What is the definition in the statute of legal custody? Does it apply? The trial court correctly found that it did not. And unless you have any further questions, I will yield the rest of my time.
Okay, thank you very much.
Thank you.
A couple of things that I would like to address from Attorney Carlisle's argument. First of all, to your question, Judge Griffin, about what difference, does this make a significant difference? The fact of the matter is that foster parents are often a permanency option for children. This is a distinction without a difference. The issue is whether or not we create a procedure to protect children when parents are exercising a constitutional right to the care, custody, and management of their child. And that does not mean that they have a right to have custody of the child themselves, because we know that's restricted, but they always have a right to participate in the permanency decisions. So this isn't about whether or not custody is going to be changed. That's the matter for the best interest hearing itself that's laid out in 63.082. I would ask the court to read that entire section. The section where the words "in the custody of the peers" is only in the section which says that if a parent executes that consent, it's valid, binding, and enforceable. All of the sections relative to the intervention itself and to to the hearing and the best interest determination don't mention anything about where the child is. The case law doesn't mention anything about where the child is. In those cases, they simply talk about whether or not the documents have been signed, the home study's been filed, the consent is there. So I think that we're sort of putting the cart before the horse. I do want to clarify that no one has argued that this statute is unconstitutional. I'm not sure what that was about. Our argument is that this statute is constitutional, that this statute defines and gives procedure to constitutional rights that already exist. I'm not arguing the father's constitutional rights. What I'm arguing is that we shouldn't interpret this statute in a manner which renders it unconstitutional. That would be a problem. If you determine that fathers whose children are in the custody of, or in foster care, have a right to participate in this intervention process, but fathers whose children are in other placements, non-licensed placements, do not, I don't know how we determine that those fathers are not similarly situated. They both are in the circumstance where their child has been removed by the department and placed somewhere else. I do also want to clarify, there was a question, Judge Lawson, about whether or not the adoption entity has the right to place the child wherever they want to, and that's not correct. The dependency proceeding continues on, and the adoption entity can place that child with the home study approved family who went through the best interest hearing. The reason that we don't just dismiss the dependency is because the juvenile court still maintains jurisdiction over that, in the same manner that the juvenile court determined where that temporary custody would go to begin with. So, and the concept of foster care being the physical custody of the department, that's illusory too. The department does not have foster homes. They contract that out to private entities. And so they go through the exact same procedure, whether they're placing the child with a relative, a non-relative, or a foster home. They still go to the court, ask for a temporary custody order, and it's determined. Right now, the department is seeking the permanent commitment of this child. So they are still controlling the ultimate destiny of the child, and that's what the statute was designed for, to remove the child from that system and give them the opportunity to be placed privately. I'm out of time.
Thank you both. That concludes our docket for today, so the court will be in recess. Thank you for your argument.